Abusiafo, Makwaba, Yenso. O see, authentication as a Maya kind. O see authentication no amaswa. Any certification no amaswa. Okay. Name there was a lawyer no for Akusia say one. That was what the original certificate. No back courts. Because what can say oh. See the court was informed. I'm not making Mrs. Mamika, I'm not making. So the court was informed that there was an original certificate. However, what was brought to the court was an extract from a family book. Into no original certificate na court need that to sell mo de baba no. Name extract and I say copy bia e free family book. German for a family book mo no. E ho na omo de buy. Name no so no. A lawyer for Akusia Serwaa edge to mu e open court say extract name and your original certificate. The document therefore could not be the original and its copy being exhibit B. Nti exhibits no mo de buy no. But say ne say an sa extract no na ono won't mean consider ne say your original copy. And no dey nyina ye ne ya adwe say extract is extract, original copy is original copy. Nti we no say therefore the extract cannot be a proof of a civil marriage. Ne say anti extract na am the free family book no enti mean evidence supporting a civil marriage between the Mama Akusia Serwaa and Daddy Lumba. Nti the extract is significantly different from the evidence no mo tro wakrata so say eno no mo dey buy a marriage certificate no. E two different things. Ne say anti court no enti me engine. Now we ye no it was the same patch you will pay 29 sorry. You will pay 39. Enti ha no we no say ne sa so e na extract a free a foreign document e sa be foreign signature said you di kan ye no. Specifically no evidence act no section 161 no ama conditions bi e wo say we dey wudi so enti when this so a entimi e ma ye nje krata no foreign krata na entum e ho no board the case of Hussein versus Eba Supra na odo Broni lawyer no aboso o say team so say senya omukura was a case ni o kura ne sa e wa asem yesu so emu enti e ho no mo no o ka say exhibit B na wo mo de ba ye no e wo say nkenya authentication no any the civil marriage certification ni nyina e free Bonham marriage registry e wo Germany no e san say mmra no e undertake senka e wo say sa de na ye den e ba so enti amaso no wo no ontimi nya ho hwe. There is nothing before the court ade bia wo de hwe ni court na ni mu e wo say court ni ye den e consider no wie no call ye mama Ernestine na fosu so a statement so no so wo ka say na odobro Akusia Serwaa ene ye papa Daddy Lumba e ware wo Germany no wo ho na mum cross examination no omo kusa no cross examination ne say ohun so omo signing was she there when they were signing the marriage certificate? She asserted that I was there. Kase no wo no mo sign emi na pay was it the paragraph 8 of your own witness statement no you claim that the only person where you answer beside you beside mama Ernestine Fosu who witnessed the marriage was Georgina and not you. That is where the can on the witness statement who say yeah mama Georgina na ojina mu ascertain no e ma Akusia Serwaa no pe e na ehun so mummy no ware na enyo no nti ade nti na afi de wo ka that is almost 30 punchy holes for witness statement no so there emu no say that be me nua be ma no o say e de me ene Georgina ene call the same day so we were living with them in Germany. That is mo wo ojitu enti no omubusa ne say nti woni me ya adwen say na wonua be ma no ne Mama Akusia Serwaa sign certificate no ono ka say ha no na what you me there is say once they were married they will sign a certificate which means one share there or as you me say anyway yeah so hu ya hu entwaso enti Mera Dorinda say ancestor na Mama Ernestine Amaye no clear say marriage certificate must have the signatures of the couple because also mummy no sign. And if not, the mere reason for an expert witness should have been brought by the plaintiff. Because say mummy no a signature ni ehun expert witness na sem ne dey. Ko say mutimi at least or mutimi ye dey. E dey ba. O say nke be speaking to the prominent features of a valid marriage certificate. What I say? Entino or say munhwe or say then a look at exhibit 0 series is supposed to be Daddy Lumba and the plaintiff signing a document. It can be any document. It grab Okay, also signing a document. Or see if the evidence is true, then a marriage certificate bearing the signatures of the parties should have been submitted. See some of the picture about women no sense sign criteria every day. Any and what's a certificate no? You must or women or signature yedin. It was so. San welcome. Into and no tino. Oh, who say women signature ni so signature ne was so near Jama official before no so 1 year they want to see. Sani my name and so see in the alternative. The absence of such signatures on the marriage certificate from Germany should have been affirmed by the expert witness. But since mudia no signature no was so kranka mama me expert witness. Mama me no subi. So we no se Ghana aware krata no. Ube hu signatures of the couple. Wa ware wo mbre mu abe hu se wo be sign. Ura be sign ana wo yere be sign. If the court is presuming German law to be the same as Ghana law, then it's a court if Ghana German Emirati said ye Ghana Emirati and then was a yehu omumi no omu signature also. So what I say. But ninyi na no ni omo de ba ye no ye hu bibia sa explanation bia so nim. It is more the reason that the document should have been authenticated because me no certificate ni so ntia no kura sa na emere nyina enti no cause at least munya authentication kakra na mutibe de boa ye and the signature identified and certified as required by government. It's still our Sujina certification. No, yes, so pay 30 in Yedri, or that is authentication as a serious matter. Into the same document is attached. The same document is seen attached to SBC, being the letter allegedly written from German embassy. The last paragraph, SBC says, attached you find a copy of the said marriage certificate for your perusal. Now, I want to know what say. Omo de krata bi fi German embassy buy say adna eno na omo trust awase no say sa krata no omo de buy no it's supposed to be the same document as exhibit B but it has a different signature and a date. The document is signed by G. Stans Bemeter, a German date and omo date no 23rd October 2025 23rd October 2025 or say any na say exhibit B no I supposed marriage certificate no so no has the signature of another Bercham. Enye Bercham stands beat him. Didn't know the Biamtino said they dated 12 August 2025. Or see the two documents look similar with similar information, but there is no explanation as to why a different signature needed. Honey, dear, she told me say, "Judge, no, ma confusing, See, you say the court has not been given any explanation as to why exhibit B, is seen. I say is at the current exhibit B, and exhibit C, because as to what exactly which one was brought as the original or said to be an extract, even if it is the marriage certificate, same cannot be relied on by the court as they were not authenticated. And now, omunina also contrary to section 136 and 161 now. Ya Boston. So ya start to concerning the see it me we see we na bibia is so now on see as no CP said the be ya nya say ya confuse ni enja we since you ni finfi nti my yanso aso nti no oda so gina authentication ni certification na so ya oda so ye wo pay 31 oda so gina wa ene ho no wo ka say SBC no mo de buy no na free foreign embassy say certification ni authentication anya den amaso it's impossible mutimi e masa execution no ekoso said e be ya anya sa nipa na o execute krata no ankosi e fresh nipa no e ma ne be kasa e fa krata na o ye de o authenticate ye to show at the crowd authenticate ye na etimi akasa kire court ma court hu at the crowd omode aba was it but the fact still remains say document was not certified or identified as prescribed by law inti no sembra no certify o krata na inti e ho no na o ka say German embassy ebi ni Ghana na ebi ni Ghana so nti no na eno na e kire adekoro emre mu no ye wadekoro nti a German embassy ebi ni Ghana inti sa na man kra kire say German emra no e foreign to Ghana inti no ko say omutimi di section 161 no so okay section 161 ma kasa unkaya classy it was say the proof of a civil marriage. That just before I prove civil marriage, and I said the friend ordinance marriage. It require documentary proof. There was a certificate. Okay, I say yeah, come back on the certificate and then your money the prove ordinance marriage. And to walk out has said before I prove it, so I worry no. I was say, certificates I chere. enti no some marriage license need together with other executed documents ni photos no ne sa na ma no enanka no ebetimi ama yehu se civil marriage bi ho so we no aka say pictures ne ma no cannot be proved by a court as it is in the case of customary marriage. Inti yeah customary marriage so I don't see pictures me wa pictures inti so the pictures but the bit me aware bia na certificate no and a dance between sa aware mienu inti o say the plaintiff ya mama akosa say wa did not tender in evidence of any video. Hey, so one tender in evidence of any video aside the purported marriage certificate. Also, Exhibit 0 series no was tendered in evidence through the first like defendant witness 1 after the plaintiff had closed their case, and so the defendant could not cross-examine the plaintiff witness on same. It's a video no. Could do. Exhibit 0 series was photographed purporting to be the plaintiff and the deceased signing a document. Without the marriage certificate, and or a video, the court cannot prove the civil marriage on a photograph alone. Which are there? Especially in the era of photo shoots, artificial intelligence. I know I cannot. The court is cautious in accepting. What the cannot say the court is cautious. That is a court to know what to know. And I say, "We're careful." Say, "We're jig in phony niema." Atum esan enembra ye woman inti without further credible corroborating documentary evidence where proof of a fact demands a strict strict documentary proof. Thus the court finds it as a fact say plaintiff no ya maami akosi say one when timi improving aware no o ka say wo mo ware e wo jama na ware no no ne senti she went me and satisfy the presumption say aware no say aware no it was authentic. She contracted where's Nasa baby that the marriage presumption that she contracted the marriage by providing an authentic, identified and a certified copy of a marriage certificate. Consequentially, for the contradictions, lack of authentication or identification, the lack of exhibits or let's say BB1 and C are hereby rejected. As they have no probative value and will not be considered for the purposes of proving a civil marriage between Yamamia Kusiasewa and Daddy Lumba. Into one Jane Crata and I am made by an antu. Crata no de by in one yantu. One yantu. Saint one yantu, no macadidant, men in a hankadi, what chirim, what tone of wet chirim. Into one yantu. A sign say, Womuni, in Bremu, the offended probative value. Sembraya Casa Woods at the any probate, that I say. A lucky legal strength. And I'm gonna say, any ahodi and I say mremu to me authority be so as I say any be necessity one jantu. And so I say this court has the right to accord not to accord the said exhibits any probative weight. And I make an you do into the court no right to say one into. Now, in Brani so a settle say inadmissible evidence, evidence has been received with or without objection. It is the duty of the trial judge to judge, and even though I be our evidence be judge and I said the NSA say evidence now the buy a bit me a judge to the abuasam and I say yen to me engine to me until I judge and I said and so. And if it is not rejected by the trial court, it will be rejected on appeal. It is one rejected wa hakra. Assembly ko appeal or mobe rejected because the same probative value it will be subjected to it. And one yemame during that or can wa say no. So this is because the duty of the court is to arrive at the decision upon legal evidence. I just said the embrani say no, san embrani bede. Ebeda no bobo cases is suma or my friend Pong and I Arno versus Rome. No my Jigson Smith versus KLM Dutch Airlines and so see on the strength of the above authorities no why exclude this marriage certificates free assembly where free one also was also considered section 5 any 1613 of the Evidence Act in rejecting those exhibits now and rejecting and the answer someone who baby you go so that's what so it just say say or rejecting exhibits no B1 na C no I reject it no say obeto so say I will consider the remaining exhibits meto so na de aka no mahwe I will consider the remaining exhibits and the evidence of the plaintiff's witness no nti ya mama akosi say wa the witnesses or the omoba no o say obe consider no so na wasan so wa consider the exhibits na aka no obe consider eno so say ya mama akosi say wa tender in exhibit D and a D1 na ye pictures of our rear if you our rear na ono ne ya papa da de lumba ye no no mu wie no so say pictures no so obia objective to pictures no enti no wajitu mu na wie no ka say plentiful no attend no ye mama Georgina ha any witness ni nyina testify say that the lumba ware ye mama akosia Serwaa wo efie 1991 na omo modern aso say omo ema evidence to sa aware no na owie no ka say paragraph 24 to 26 of evidence in chief of emame Gina Asemwa or the court no exhibit G bisu was a series tendered in evidence of a video the deceased ye papa Lumba Moka said his 60th birthday no e will be View Village or refer to Yamamia Kusia Serwaa as Nigeria or Dinisika e ware no no kai o se meyira Kusia Serwaa matim sika ware no aye ne ho ade nti no e hono mo no court ne say the video rather purports or say the video supports that the Lumba married the plaintiff. That is a video that supports say that the Lumba ware ye mame e wo fie ne mu menye senye I say not otherwise, and this is more consistent with the admitted evidence on record. I say no edim na wo say mo record so mo di be nyina no enu mo prove say if ya ware bi ko so between that the Lumba and ye mame akosia Serwaa na emu menye court aware said ye wo mo ka no. And so see this evidence was not it was not disputed by the defendant. So see if any abusia panyi odo Broni mu bia answer the enti asa asemi say ye papa da the Lumba wan ware ye mame akosia Serwaa e wo fie mu bia ni ho a omo anka se omo gitum omo nyina gitum se sa if ya ware dem de e wo ho and sisa no court no agye atum say ye mame akosia Serwaa one da the Lumba e ware wo fie e ye if ya ware customary marriage no. And as earlier mentioned, no, the customary marriage is potentially polygamous. In the sense, there is no limit as to how many wives a papa Lumba will be to me. Say, me yedi kaka customary marriage no was a one shot. The question just our class no, family lectures. It's na nesa no say ni intimate waso. I'll move on to the crux of the issue, whether the plaintiff is the only surviving spouse. So so the second defendant, odo Broni, ye mame odo Broni. Aye. O say o counter claim me that is what tia ye mame akosia Serwaa asem so no nko ane yire ne say. Wo no so ware no wo fie. That the Lumba ware no wo fie mra no wote ase. Nto no so ye yire e ma that the Lumba. Na o say as indicated earlier no. Ono so bear the bed so be prove say ampa that the Lumba e ware no wo fie. Na ono so free witness D2 witness no so be kasa fa ho say o ware that the Lumba ware no e wo fie na wan ono ankasa ama be yi a be kasa de na emom ne witness no ene ne interrogatories a wogi ano no under oath no eno e kasa ye enti nyina akere say she was married to that the Lumba wo fie osa so my list of abusuaphobia no mo ka say say me happy say this three okay say your list of relatives bi so na omo ewu but na omo wo aware na say enti ne witness no so ba ye no so testify to the same okay say wo hu odo Broni sometime in 2006 about 19 years ago no okay say odo Broni any the disease no mu date for about 4 years and san wo mo ware e wo April 2010 mo wa chada ma date that point but o see April 2010 nti o see the only witness that will testify that he was present at the customary marriage of the deceased or no pe ene bae so what I say or no na e bae nti D1 no or no bae no so tender in evidence four pictures a video is SÈČRET that the Lumba or refer to odo Broni se ne yere expressing o kan da o dono any o ka say odo Broni hwe no one ne ma ene sa ne ma ne nyina o de sa video no so ye den e be dan court o wie ye no mo sa de another video odo Broni that the Lumba refer to odo Broni mame say nase or refer to odo Broni mame say nase no we no ka say or say and saying that he has 2 mother-in-laws or di 2 so wo and se no mo ma mienu and se no mo ma mienu na che say odobroni e ma me ene ne nanaba enyina ayeden etiase omo di video ada de lumba eje e kasa asem no e wo mu no etimi e de bedan court pero for me sama wakwaba omo di video yi e bedan court no court ni ji video yi nyina etum court ni ji video ni nyina atum na oka say ni odobroni witness no ma a vivid account into no court ni asem bia na omo beka afa ho niema okeka yi nyina no or say or ditum na ye credible, coherent and consistent na ne nsam no esisi so entutun sisi na emu esisi so kama enti ne evidence no so na enye contradicted and na o ma credible answers so e wo court and na the evidence no or say the evidence of a single witness no or say na chese nipa ba ko adanse no ye credible no is also reliable e sufficient to say be prove an issue a we in dispute that is asem a bia entawantawa ba ho nipa ba ko adanse etimi emboa ema yebua sa asem no enti sa witnesses nyina no are weighed enti witness no ye weigh no enye numbers nya sa odi nipa bebere aba be kan asem no nipa ba ko asem etimi ebua me yebua asem dan nipa bebere a o masem no sisi so a endem atwanya na make kan asem ye rad me nyama na make kan nyama na make ana make kan brofo mun kan kire mo nyama na make wa ai enti no oka no it's one or since therefore a party does not prove its case by multiplicity of witnesses called that how page 34 me bo akoshe but by the quality or credible or reliable evidence led at the trial by himself or by his witness. Oriye normal case see Ghana Port and Harbours Authority versus Captain Ziem and and Captain Ziem versus Nova Complex. I know serious Sama Muzamba Disco Christian Church versus Yehuapia. It was furthermore no paragraph 18 of evidence in chief of D1 Ebusia Penino states that for the last 15 years that disease is not bontension otina assassination na one odobroni enete and as one odobroni mami odobroni ne worry nti osaso ka say ni okoba bia na one odobroni na eko ne ohia ahemfo ohia president atitrufu nyina na one ne na eko ne senti no odobroni illegally married wife wa ema ye papa da de lumba nti osisa evidence we no e ma me akozi say wa momentiem evidence we ya omode maaye no e ma me akozi say wa omontiem omo na make come yeah say me menya say mo also the evidence was not challenged by the plaintiff nti omontiem nti no abusu apanyin or the pictures etre ono etre odobroni ane papa lumba our public appearance and to see most of the pictures they were dressed in similar colors. There's some color matching with the disease holding the hand is a lumba aso odobroni inside na sisi one dignitaries to say IGP Asia and I was almost asked odobroni ma any yama me akosi say one ma pictures esa so be die court so odobroni ma ni akosi say one ma omudi akro omotibo ma no mo ye bibi omo de picture by picture na me nya hu bi but aha no say inte hono no say e ma me Ernestina the sister of the deceased tama no mo toto na no even though oka say odobroni ware daddy lumba no osaso admit say odobroni ye na se ye na kuma as she is caught on tape nti wo munya tape bia na ye ma me Ernestina wo ji atum ona se wo frɛ odobroni na se ana na kuma de be ono be na kuma wo ho frɛ na kuma ai no mo frɛ na exhibit JB2 series o refer to her as akuma konofo medofo loving sister-in-law any mrani bisa na make come I say as her sweet sister-in-law loving sister-in-law among others na make come it is noted that the customary law marriage can even be accepted through the conduct of the parties during cohabitation and only as a besa abaso say customary marriage can formal informal customary marriage no ho na ye maame Dorinda all can. Say customary marriage if you are worrying, you were quite bebre. It's me eba. Into no work has in work actually say. Sa worrying, a bit to me I accepted through conduct. Said them one cassa, mokare moho. Some mukoni pemuna mo from who so kunigere. Now be a mobusu and phone in a jimutum secunigere, be a jimusecunigere. It's me eba about as a customary marriage. Into a and I said through long cohabitation 10 years, 15 years. It does not require documentary proof as marriages under ordinance. If you are no share there here, crata would the better say our rear, be a woman to set the ordinance marriage now. Na ye mammy, I could say, where can we hear cratano? No, ya mammy and Estina, ye busan say, Nebusia, recognize it. See whether her own family has recognized. So, Moji, ya mammy, I could say, what to say, or ye papa lumba, by giving her upkeep money, or see when him. Someone himself and time member say, Kunani, Nikunu Frima, I was say, Busiano Bona Conhoma, or Mubusai Mamma and Estina, I was with him, so Mobo, ye Mamma Kusia say, why a Conhoma, or sue him. Or see, she does not know whether her family has notified the family of the plaintiff. Or names with some than Saka, or say, Mamma Kusia say, why, and in a Busia say, a year said that the Lumba, a Wusenium culture children and our customs children. So what I said, amamre children. She expressed surprise when she was asked whether she knows the plaintiff is in court because she is not the only. She wants to be the only surviving spouse. Or say, they say, when him say, "Yeah, my could say what they are some number court say or no one a year no." I say, "Yes, say and one cry." Yamna miko, yamna make camino. Out of yamna miko was saying in pay 35. 35. What I when we make Caribbean share, I paid number no question. I paid number no question. But see, she expressed surprise when she was asked whether she knows the plaintiff is in court. Is in court because she wants to be the only surviving widow of the deceased. Or we are not say the answers went like this. Question. So as you sit here, do you know the plaintiff wants the court? Do you know what the plaintiff wants the court to do for her? Or say yes, I know. And Musa Busani says so. You know she wants the court to order that she's the only surviving spouse. Or say I don't know. Hey! Eba. Or say I don't know. When you see ye. See hono. And my lady say. Eh, the one pa say. Eh, ya mami Ernestina. Or say. What did you say? Or Kosra. Or see who admitted visiting Daddy Lumba, the deceased. Any other Broni. Abra omu omuba wedi kan ene nia ena nia otaso me ensakra no yeto no omoto ne bedin say wotimi di adanse ye say odobroni enya yere o say ye ne nwanwa ena eye nwanwa o say eye nwanwa sanse ya wato bedin nyina wu nti na ye no eye court nwanwa nti from her own ancestors na the cross examination she has been very active. Ewo odobroni ene Daddy Lumba aware mu was also confirm say na odobroni tie friend pa according to her cry no na Daddy Lumba sheda e ka kire say one pe baby emma odobroni ene omo last born no ewo Germany said e be ya omo ba be ye ne passport nti for the audios na or they come out odobroni no asisi odobroni the back or that is odobroni the audios no kai JB evidence JB series na me kan no or the bias you know na ya mami Ernestina succeeded I would deny no say deny say oni names odobroni aware Lumba na say o ye ne kuma just say court na mama kakra court na mama kakra counsel for the plaintiff Esoso Chroye, when a written address, say an issue was raised about the venue of customary marriage. Show, I say in Riti, Haniti. Mammy, I was just a lawyer. Or raise the issue, say, baby, I a year or Dobroni, one dear no. Baby, I a year or Dobroni, one dear no. Or Dobroni, Lumba, warrior. Or muye wo Lumba fie. A lawyer phone in a say. They say I said a lawyer phone in a money must say home. Already she said, baby, a year or Dobroni, one dear no. A year will Lumba fie. have noted some marriages are contracted at event places. No, judge and say, "Me who say whatever you are, you event center, maybe a hotel, maybe a park." Ni senti no. So mushia wo lumba fie na omoware odo Broni no. Entimi masa awade na enye invalid. Ana say entimi enye enu nti ne ebeka sa awade no. Enye awade papa wo mrem. Enti ni ehia pa ne say parties mienu no wo mu di to mu so mbe ware. E na ebusua panyin ne je odo Broni trinsa. Ohun ade kronti a won ton mani nyintum say sa aware we na ejinem asem na bomo nti owie ye no say cancel for the plaintiff o see o raise ono a o eye e ma me akoze say wa lawyer no o say raise questions say photograph bi a exhibit bi CKF2 a omo tender in evidence by eye ebusua panyin indicating a picture of Papa Lumba any odo Broni or say it's a picture of omu abra Lumba omu ye Lumba interview say omu wari ye no omu ye ni interview now already no indicate say ebusu apanyin no ni friend say ase na won sha de nim Lumba obrani mu asem papa enti no wedi can indicate that enti therefore she finds that a fact say odo Broni na waware oni Lumba wari fia ware ansa na wo also no of finding as a fact say omo ware in 2010 having so determined no that is they say wagya to musa no ya mama akosia say wa ono nko antimi nka say ono na ye papa Lumba eyere baako only surviving spouse. It was say I must state that even if they had contracted a marriage, even if they had contracted a customary marriage in 2010, ewa asante amamre mu no so omo ware ofie mpo ewo 2010 mu a sene PW2 ebeka ye na expert witness na omo de ne ba ya obeka asante aware ye ho no ama echese odo Broni oye yere mo guys I expect witness na sem expert witness na ye ma me akosi ase wa lawyer okofa ye no no ye expert witness a oni masante amamre ene asante aware ye asem yes sir or expert witness no medical consent we are making what's the decision I expect witness na asem obeka yi nti no ye gina so aka say odo Broni wo ye yere me da ase yes see expect witness na ya mama akosi ase wa lawyer de ba ye no na asem obeka yi nti no odo Broni wo ye yere anana wabeye yere had become nti na wabeye yere of that Lumba esan say ye wo kwan bebre so a customary marriage and if you are worry no ultimi eye no na e ko beyond celebration nti no witness no ema expert witness ne ma niema kwan bebre so a ubetimi ana say relationship ayongo fe da oba ne be mantem e betimi afa ne say eye amamere aware ana say if you are worry na one of such no is when an elderly man and I say papa penyi woni ran into amoros na tese mpena twemu ene ababa woni ababa we ran mpena twemu a na say ebusua ne hu a na oba na ebusua no etna say omo ne be ma ne tena say no omo accept say oba ne sa be ma ne nkotena as ne yera oba ne be ma no ma be ye okunu ne yere ana say obe ma enyem oba na so wodinyin se ni tum woto akwara ne din a eno so e kire se o ma be ye ekunu ene ye yere na sa asem we nyina sa ne ma we nyina e ma odimi sa empatry no asaware nti they are deemed as husband and wife kata ne na ekomunyeme ne se nti if you are worry emra no wo mu say ye wo amamre bi ni amane bi a ye ene saa ne man na mum no there are times ye wo nkrofo bi so a wo mfa saa kwan ne so se ne ya prescribe na na se ne da ho se wo mo ye den efa so no nanso abusua no agi aware ni tum se ya aware se ne expert witness no ye ma me akosia se wade ne baaye no ebe confirm ye no enti efiri ne ye keke nyina so no 11 issues ni nyina ye boa they've been determined. Until I move on to the other leg of the second issue. It was who called the second leg of the other issue. And only say, was say, Mamma Kusia say, one uncle and edicuna. Senye or per se court no yamano as the only surviving spouse nana. Into how or becasafa, widowhood rites. A yekunedi. Say, a ye kunediani a custom ni cultural practicer, incidental custom and cultural practicer. Say obi ewua ye yema ebusuano. In a sense, in a say obi kunu ana say ne yere efiri mu a. So they do as part no na say nipa na awewu no ne body no ekọ nechi eye na ebusua ho. Nti moti ase na moye mo ho de na mu wudi a body ne kọ ho aho ebusua ne ho nti woti ase de wotumi ye wukunu na wo yere de awu a onipedua no eye wabusua de nti ekọ nechi o kyerkyere mu wa ha ame no ya de kyerɛ de wa ha pa nti no se saa so na e wada de lumba asemi mu a wo sa ya santini na busua no esa akọ ne matrimonial matrilineal lineage ye frɛ omo royal family of Paakoso eni insuta omo ho na dadi lumba omo ne own ne body no nti no say the performance of widowhood rites so obedi kuna no enye an entitlement as I say you need to be married there was a worry ne ewewu no nti won worry na nti ntimi nkwaye nkodi kuna ma mpena edi kuna ema ne waware no yire ana ase wukunu saa no wo kyerɛkyerɛ yen nti owie no ka say in a sense nti no it cannot also be used to disinherit a surviving spouse na mu nse ma mpena ma obi adi kuna wontimi nka say we adi kuna ni nti no wo mani ndi ni kuna de ana wo mani ndi ne yera de oka wa ha enti no no saa cultural injustice no PNDC law 111 na so okay PNDC law 1985 no addresses saa issue no enti widowhood no a right it has to be performed so what I say I determined by customs na mom enkyere ni obedi ade ni wondi ade na ehun sensem nyina no ma panyi e wa abusua mu no wo mo na ekyere nti owie ye no to asoka say expert witness na yede ne ba ya obeka safa Ashanti culture ho no Asante amamere ho no wono o say yie no o ka say yie both spiritual and physical nti no say obi nya yere a o say therefore if there is a wife or their wife say what's any pakro no wo yekuna so obi ye yere a wo say wo yekuna esan say Asante amamere ne spiritual yie spiritual and physical nti wo ye yere wo say wo yekuna nti no emma no it is the women who are nti ma na ya ye omo ho ade wo fie no wo mo ena saa mmere yi ekata omo so nti sa wo ye nya omo ade wo fie a wontimi nkonkodi kuna nti no enema bi a expert witness no keka ye eni expert witness yi nsembi nsemba ako ene say ye wade bi e betimi agina so aka say ma wo yiri bi endi kuna na ene wo say ya nsa abusua bi ehwe say aware no na ebi a ba bi aware na duru na aware na gu ana say wo mo de hye no ne yere no ene na antena yie ana say woni na antena say wo ye na sede se wo yere a abusua no etimi ejina ejai ya na say wo mo prevent obi say obeye kuna enti na times no ye successful ebi also a oyere ne kokopa acho na omo de dwantoa akwa oyere no etore bi so a oba no etimi de acho pa ekokoma okunu na busua na omo asai agina tum na omo aye nhihye ya apene ama na di kuna no nti saa anu ye ya expert witness yi ode ba yi so such witness of the plaintiff ma me akosi say wa witness de ba yi no na che say ekunadie no ejina that the lumbe busua so nti no omo na nti they decide based on how the spouse treated their deceased relative so what I say ne sent na busua no that the lumbe busua no and they was say wo mu decide ni a wo ye yere a omo pese wodi kuna nti se abusua no eje kunani bi niema tumu a de omo di dware no ne adisiedie ene ye ho niema ni nyina no so omo di tumu a na che say it is pertinent for a spouse to respect and live peace. Na just say what say oni wukunu abusua na say wo yere abusua etena yie na motena asumdue mu se ne be ya saa niema we eba ombepene ama watimi ayede edi kuna awarigo divorce awarigo asaso kasafa awarigo ye divorce. Also, the combined understanding, say working kind, the law of family in relation to Ghana. I know WCA for Daniel Senatroye, or refer to page 319. JB Dankwa, the extrajudicial divorce procedure. Any William Ye of Fair book, or also try of family law, Ghana, family law, 4th edition, page 172. No, say, a quine a fast so that is dissolution of customary law, together with evidence of PW22 of us, our books. Omo ensebo mo trofa aware yefia wade gu mu na ode PW2 expect witness na mama akosi ase wa modene baaye no ode ono so na no asem ka ho na o ka se wo pese ugu asante aware a untimi enye ne sa abra wunhia abusua menu nyina untimi ngu asante aware abra wunhia abusua menu nyina also no e was say nia odi ya wana say nia o pese ugu aware no e was so wode complain eko so what you say also wode complain tiko. Na the parties no so no was a yeti or more asem according to the rules of natural justice na was a wutie masem na mesusu ma me kwan na mesusu me yede come asem na say na mesusu tie wasem so the right to be heard what I say na we so I won't mean a judge wo wasem those two principles no was say no so ebem nti party bia was say ma party bia ema ni kana asem na odi na asem so you will pay 38. Can I cry? Yeah, into pay 38. No, aye. Into obusa o honom no so no osasu ebusa say na so mutie nsem ne mienu ni nyina no mu hu say also mo try so mo beka mabom na say enkabom na anye yie dia ene na che say also oba no e de be ma ne tirinsa ebre na busua na ejapade bi wo wontamu a ya cha amomo na especially say dwaman be mu a ya cha ejapade no na empata ya bem especially say dwaman e be mu a na empata abem na ebusua panyin no ana say head of family no be ma na ebusua panyin no and they also make a pronouncement say that is there has to be a pronouncement e free ebusua panyin ho say aware no egu nti omo de wo ba no asama na ebusuafo saa na ema we nyina o state as a che kwan a ema efi aware egu. Into also the maybe one meeting where it will not end with the dissolution, but a baby reconciliation. Just any na motena see a guawari and a bill high say our no. Imponu say ye share see be guawari and a bill on one tia say to me a juma Emma yedi see not say or ban where nyam fat in sana uncle. It was also referred to the Matrimonial Causes Act of 1971, Act 367, no can say. Emra govern the dissolution of monogamous marriage, ordinance marriage and a court marriage. As soon as say court in the jurisdiction say, "Womugu awari." You know why the court in the base me guna awari. Ni edika. You say nipa ni a citizen of Ghana. Aye, and I say what in Ghana domiciled. No, te base never say what in US, but you are domiciled in Ghana. Aye, domiciled, next citizen. That could make you chip. Into no domiciled in Ghana. Has been ordinarily resident in Ghana, or at least what na has say 3 years. Abro so preceding time I will file divorce now. Was so Ghana mra, and as a Ghana court, ebit me egu aware. Now was a party be approved to court and say aware na egu kura ye onhwea enye ye. And unkwa is the sole ground out me digina so awode ye dey. Udi gu aware. Notwithstanding that, no what raw or about the other reasons are ubet me agina so edi egu aware. Ba akoya adultery, unreasonable behavior, desertion. Separation without consent, and also for 2 years and 5 years of separation without consent. Ni na ye nema igina so ye de gu aware. Inti parties na ntimi ankom asem a court no ebetimi ye gina sa ansem ebi aso e de egu no. Inti ebi on ma court ni timi hu one or more of their reasons ni nyina otimi gina so etimi de gu aware no. Inti age se court na satisfy no ho sa aware no ye hu hwe a enye ye nya sa court no onye den wo mu no nti no bi o ti bi na ware ko court is mo ko try reconciliation court is mo ko try reconciliation afi de bo so mo ko try reconciliation about 2 years o meba na wo ba na nyam no mo chantuma ba ko efra no so we za asem ne bi no it is pa na me say o de wo client wa ko file divorce akọ court na o say ye nsia wo court beba no ni kunu sha atade ba ko ye hu nsem right o say ye omuni onu de oni record bia e che say ye ma me akozi ase wa ni lumba o mu ja awade letter ne pe na e wo ho na letter no so enchere se o mu de ni tirinsa esa akokoma lumba ebusua into the next issue they say about be decided say plain evening lumba no 17 years na wo motena in the constitute abandonment na so kai say maybe one year 5 na e digu aware ne so no say montematete for 2 years montematete for 5 years we year ka 17 years into no e matter na e was a court be ka say na de waka nyina idea say just aware no e wo ho no mo na emom no because of some mara into no was wo determine ni nyina na wo tsimara na siye into no sign e boss into was see afi na wo be determine na o ka say from any ama o makeka na witnesses o mo dia ba nyina no e che say that the lumba esa ba Ghana 2013 and a lawful attorney no e kasa o mo busa no si 2013 no mo busa so on the record no that the lumba or relocated to Ghana permanent and I say it was 2007 and 2000 no see there be or no the last time who that the lumba was Germany no 2014 but permanently ni no 2017 no almost say then after she had denied already giving answers until later no or sabe deny answers here with their men and that is also many evidence in why ha but you agree with me that at some point the disease relocated to Ghana also beja to say a dream bia that the lumba start to betina Ghana or say oni ma fikra yiba that the lumba ba Ghana no musa busa ni so betimi a kire mmere a ko say wa so relocate from Germany eba Ghana na or say no there be akosi say when relocate and free Germany and Ghana enti da attending make attending be no say akosi say wa Adamfo Georgina na eka say the attorney could not answer most questions averred enti na just say bebira yebusa no no wentimi anya no na already na wedi ka boso say akosi say wa entimi entu any that the lumbe entu amba because na e wo say otua mortgage ka no show mo ma no wo ho say sanse no mu susa na o lo bi susu na e wo say oni that the lumba age a e wo say o mu tua e ka enti na ono no wontimi nye den enja e ho no mo emba Ghana enti mo ma yenhwe na yeto aso
Part 18
yeto aso yegina divorce kwa o church mu divorce na asa warego enti ye na ra during that o church mu no say and cross examination that's just a summary defendants and a lawyer inti ya ebusia panyin ene Broni lawyer toto ya mama akuzi ase wa ejina musini a obe di adanse ya ma no omo toto na no wenti mi anhye da ma details bia ena nsem bi ono ma odinaye no outright what I say enti no ase na ne answers no o evade answers or see evasive answers and no ono asa contradict ono any evidence enti na say na won hyeda ani masem ne ho kra na alleged loan na okeka ho asem ni nyina no wan hyeda ebo no bank na oka ho asem bank omuji loan ni free ho date omuji loan ni hwan ya ji loan ni nyina wentimi antre court no na saa so na omu under cross examination musa busa ni say mortgage na wose na wose mama akusi ase wetua no eno so omu busa ne ho asem no busa ni say na obeje atum say mama akusi ase wa oye ne yere anase ne wifely duties ema that the lumba bra na ose Ghana na ose wono na owo Germany na akusi ase wa wo Germany no ni Ghana no musa busa ni say nti amre na lumba wo Ghana no na akusi ase wa ena ye in charge of the properties in the business ewo Germany na ose I believe so nti wan ka yes or no na mum asesa ana me gidi sesa enti no ose sa answers we na confirm say mama akuzi ase wa wentu ama Ghana oni lumba entu ama Ghana na me ho aso so na from clear evidence on the record say we free Germany e ba Ghana for medical attention enti empo say ne atene no e ka say in 2013 no same cannot be correct. Say or no same cannot be correct because or no one kasani evidence or paragraph 19 say Emma Miakusia say why by Ghana 2011, 2012, 2014, and 2018 said ye di can abosono. If say that the lumba eba Ghana 2013 and then actually say Emma Miakusia say one and possible say with me best no 2011, 2012 because that's that time no that the lumba any Ghana. Inti was in same way to see in any case no sad dates we like Broni ese enya no kure esa say sad time no na one na ware na one na sit Tantra Hill inti no ansakwa no mubeto akọ easily go 2016 mu ono wode ne nkrata ba e wo record so inti sa fact we nyina PW1 aka say na D2 so ne net no ni nyina na say from 2010 to 2016 there enya possible say sa asemi esi na mum na one Broni na ye de ete Tantra Hills. Now, okay, no paragraph 8 no of the statement of claim of Emma Miakusia say one ka say omo won kwada miensa 31 24 and 20 na saa so na omo say repeat of paragraph 13 wo evidence in chief of attorney no eso asem na evidence ni say omo last child na the 20 no se si ano pe ono ani evidence o kan ye no che say the not plaintiff no at the time that the lumba eba na just one see akwara because it's not just a time I work can not just that time na akwara no isha omo last born isha inte che say na that the lumba e relocate ba Ghana 2005 or say 2006 enye na emom enye 2013 as the last born was 12 years and definitely not being nursed or breastfed at the age 12. I just say time I war ban na ne ban we 12 it's not possible say what no for no until say I followed from the plaintiff's own account say me also no ankasa wo hwe Emma Miakusia say one account na no who say that the lumba na wa work Ghana bare 19 years I work Ghana bare 19 years which is consistent with senior ebusua panyin kan ye no say wo hia Broni any that the number 2006 no mu date for bare 4 years there be onya busa panyin na kai Broni e witness no Broni witness no on ADW1 o hia omo na omo date bare 4 years and san omo ware wo 2010 enti no court no obetimi safely akase that the lumba relocated to Ghana e wo bare 2006 that is bare 19 years ago na that the lumba court na si we relocate ba Ghana. Medofo. Yebeseshia. Muza for me some wakwa baby mu na ye to aso. There's so na divorce wa baby a court na church mu aware go ne say aware ne na egu ana say engu ye no. Ogusu church. Na ogusu church. Osaso be ka say enya possible say 2011. Ye mama akusia say wa be strada do me say Broni his first born or only 2011. Nti sa visit na omo tro say 2011 year you know enti me nya no kre no saka say even if she did that any say no kre so ba ya want na ni kuru da de lumba nchen esan say na Broni ene da de lumba ena na ete ho enti no ne e wo kan aye no enimu sa o say enti me nya no kre esan say na sa time no na Broni ni lumba na Tantra Hill na what is mentioned and not disputed and it say akosa say wa eba Ghana in 2008 to be seen him ame no kre na account na omoka say the account is not disputed by any of the parties say answer no party no obia anka say no kre and as like obia entiam say no kre nti obia gitum sakosa say wa ba Ghana 2018 be ye ne maame ye na na sambre no so no what Tantra abra na lumba ene Broni ewo islegon senior ne witness no e kan under cross examination no na say court na kira time my mama akusia say wa ba ya obeye ne maame ayi no na ono kotena Tantra Hill na da de lumba ne Broni ene ti islegon ho na da de lumba efiri koye ne maame ayi ninsi yi no ende minimum you and I were not there Tana court and say ono de o hwese de ne de ma betutu n'animu a o yi fair che ai ti under cross examination no ne ohun ye no Enti whether 19, 17 or 15 years no see emfa hone o say 19 or 15 years o e betimi a che say sa emre are more than enough to confirm say Lumba any ya mami akosi Serwaa they had decided to stay apart, you know. It is not disputed say Lumba e nya surgery e surgery will focus 2013 will focus na akosi Serwaa ama mbesra no. Enti from D1 exhibit no ya ebusi apenyi na exhibit no video no continuation of plaintiff no exhibit gin odo Lumba eka say he was bedridden for more than 5 years and expressed his gratitude to Odo Broni say ohwe ni yi emra na oyare no. Enti Odo Broni witness no so confirm say na Lumba o wote akonwa moti wheelchair mu wheelchair minim wheelchair abra ono kosra in 2013 abra o surgery video no so wo hwa e kire say Odo Broni na Lumba na nkasa eka say obeye bedridden and so beda mpem ebro 5 years na ono Lumba no na ontimi enko Germany until 2014 omu state say attorney no mama George na ka say oko no no so na enye no kre enti baako ade baako ye clear say na akosi Serwaa ma no omu besra omu papa eni Odo Broni ewo efie during omu summer vacation na pictures so wo hwa e corroborate sa verment nyina Odo Broni mo de beda in court sa aside pictures nizo nyina no omu de baaye no assertions say nkra no ekosra omu papa that the Lumba no na omu ni ono eni Odo Broni net na aye no eno so ewo enti question ne say akosi Serwaa oja that the Lumba ware ewo ni emra no ote ase ana na wo hwe evidence ya court no abeda court n'animu a o say answer no in the negative. It's say according to DL exhibit DL1 no letter written to the disease akosi Serwaa man lawyers for try no woman 10 days say one farm proceed to German court for divorce. Na sa letter no so no address no to ye papa Lumba na nkasa plaintiff no so wo copy. Na sa letter no so embo akosi Serwaa din na ne reply no ewo paragraph 9, 11 and 17 no na ne lawful attorney no so ka say deny say o ma ne lawyers no instructions say o mo ntro no omu lebu na fictitious. Enti plaintiff no mama akosi Serwaa ne reply to D1 was in direct reference to exhibit DL1 no sa letter no eno na ono oyi ano